I do believe that the Constitution does, in fact, set limitations to the discretion, to the powers, to any act on the part of the Senate. It's very clear because the Constitution says that the House has the exclusive power to initiate, and it did that already. The House job was concluded. Now it's the Senate's turn. And what is the job? What are the specific instructions of the Constitution to the Senate? To me, it's only three. To convene as impeachment court. They did already, but they have again to yet reconvene and imposing all those requirements for purposes of reconvening. The second instruction is to hold impeachment trial, to receive evidence, to look at the evidence, to evaluate the evidence. And the third instruction is to render a verdict of either acquittal or conviction. No other verdict, so to speak, can be rendered by the Senate as an impeachment court. In other words, to me, reading both the Constitution and the very rules of impeachment adopted by the Senate, what we have is that 2011, with the resolution number 39, that was during the time of Senate President Enrile, which was adopted for the trial of former CJ Corona. There's nothing there about dismissal of the case at the first instance or even before the holding of impeachment trial, both in the Constitution and the rules of the Senate. So where is that coming from? So every time that the Senate or some members of the Senate come up with certain invented procedures or invented technicalities, which to me, serve as barriers for the immediate holding of an impeachment trial. And the immediate is very clear. The word forthwith is very clear. So this is being violative of the Constitution. So far, the steps and the moves taken by the Senate, especially the pronouncements of the Senate President, are, to me, violations of the Constitution.
The actions of the court is actually sanctioned by the Constitution. The express power to solely try and decide a case is given by Article 13, Section 3, number 6 of the provision of the Constitution. However, we always forget that for any court, based on the case of Defensor Santiago versus Vasquez, there are also inherent powers. It's not only the implied or express powers that is given to a court, there are inherent powers. And one of the inherent powers of the court under the case of Bilag versus II is to first determine whether or not it has jurisdiction over the subject matter presented before it. And that is what the impeachment court, in its textually demonstrable commitment to exercise its sole power to try and decide, has done. It has interpreted its power to try and decide and actually exercise its inherent power to determine the sufficiency of the articles of impeachment. The only limitations set by the Constitution are under Section 3 of the same Article 11, which is Section number 6, 7, and 8. First is that the vote should be 2/3. Second is the penalty cannot extend beyond removal and the disqualification, perpetual disqualification from holding office. And the last one is a self-imposed limitation or regulation so as to give the Supreme Court, with the judicial power, to actually have a manageable standard to see if there is a grave abuse of discretion, which is the promulgation or to adopt the rules for the exercise of its power to try and decide. So on that matter, there is the power of the impeachment court to see that whatever it is trying in front of it has basis in law.